Good afternoon and welcome. My name's Tara McInnes and I'm a partner in the Burnside Partnership. I'd like to welcome you to the second video in our series, Emerging from Lockdown. This video is on lasting powers of attorney and is presented by Stephen Trevis. Before introducing Stephen, I'd just like to say a few words about the Burnside Partnership. We're a specialist law firm with a team of experts advising on private client, contentious wills and estates, tax and trusts. This series, Emerging from Lockdown, takes three topics: wills and probate, lasting powers of attorney, contentious wills and estates, and considers each for reflection on what challenges have lockdown created, what's been learned and what's changed, how might those lessons and changes be applied as everyone emerges from lockdown, and as we all hope, normality resumes. So I will now pass you over to Stephen, who's going to talk to you today about lasting powers of attorney. Thank you.
Thank you, Tara. As Tara said, my name's Stephen Trevis. I'm a solicitor with the Burnside Partnership, dealing with private client and cause of protection matters. And I'm going to talk today about what the pandemic has really taught us about the need to have lasting powers of attorney in place. Next slide, please. My short talk is going to cover the subject in three topics. The first is going to look at the pandemic and the impact of a sudden loss of mental capacity. The second section is going to explain a little bit about what LPAs are, and the concluding section is going to look at why it's important to have an LPA or LPAs in place. Next slide, please. So one of the things that the pandemic has highlighted is the impact of a sudden loss of mental capacity. The common perception seems to be that capacity is something that affects older people, that is a gradual process, and that is perhaps something that you don't really need to worry too much about until older age. This is probably a mark of the success of organisations that campaign on behalf of people with dementia and their success. However, there are a number of circumstances where you can lose capacity at any age. For example, an acquired brain injury as the result of an accident that occurs, mental health problems, and as we've seen in the pandemic, there's been a great increase in people having problems with their mental health. And there's also illnesses which cause a sudden and debilitating, or which are, sudden and debilitating, which cause a loss of capacity. And that obviously has been one of the strongest features of the effects of COVID-19, where people sometimes become very ill and often are in an unconscious state for a period of time. I think we are all susceptible to the attitude of putting things of this kind off, but I think the pandemic has shown and given us thousands of examples of why this is perhaps not the best policy. I'd like to speak about one of those examples, and the story of the well-known presenter, Kate Garraway. Next slide, please. As I mentioned, Kate is, as you probably know, a well-known breakfast TV presenter. She's married to Derek Draper, and he fell ill with COVID-19 during March 2020, at the beginning of the pandemic, and at the time when lockdown measures were being put in place, and has essentially been battling with the effects of the virus since that time, spending some of that period in an unconscious state. Although I believe he has returned home now, he continues to suffer the ill effects. He was therefore, during that time, and in particular when he was not conscious, unable to make decisions about his finances and welfare. He didn't have lasting powers of attorney in place, and this meant that not only was Kate unable to manage his finances or healthcare decisions on his behalf, but they also have shared assets, or the shared use of assets, which are nevertheless in his sole name. This meant that not only did his illness and loss of capacity impact on his own affairs, they also very much impacted on Kate's affairs, and she was left unable to manage their shared financial situation. Next slide, please. So what are LPAs? They replaced enduring powers of attorney, or EPAs, when the Mental Capacity Act came into force in 2007. There are two types of LPAs, one that deals with your property and affairs and one that deals with your personal welfare. They need to be registered with the OPG before they can be used. And decisions must be made in the donor's best interests where they lack capacity to make decisions themselves. And in many respects, that last sentence encapsulates the entire framework of the Mental Capacity Act, which requires that it's first established that somebody lacks capacity, and then if they do, that any decision that's made on their behalf is made in their best interests. Next slide, please. Looking more closely at the different types of LPAs, a property and affairs LPA can in fact be used as an ordinary power of attorney before the donor loses capacity, if the donor opts for this within the LPA document. That can be useful because there may be times when somebody is having physical difficulties and requires help with things like trips to the bank, etc. And if an attorney is already empowered to do that, then that can be very helpful to the donor. If that's not the case, then the financial decisions on specific issues can only be made if the donor does lack capacity. You can use your property and affairs LPA to do various different things, ranging from paying bills to signing checks, to managing investments, to buying and selling property. Next slide, please. By contrast, the personal welfare LPA allows the attorney to make decisions in relation to a person's health and welfare. But unlike the Property and Affairs LPA, there is no option for a donor to give authority for the attorney to act before they lack capacity. So if a donor in relation to their personal welfare has the capacity, then they have to make the decision themselves about the various issues in relation to it. If it's established that a donor has lost capacity, then a personal welfare LPA will allow the attorney to make decisions into residence, care, and treatment. And also, donees can also be empowered to make decisions in relation to life-sustaining treatment, and have the authority to refuse or consent to life-sustaining treatment, which is obviously pertinent to the situation people found themselves in during the pandemic, when they may not have been in a position to make decisions of that sort for themselves. Next slide, please. So why is it important to have an LPA? As I alluded to earlier, capacity is not something that is definitely going to happen or certain, and hopefully won't happen. The difficulty is that the effects of not putting in place instruments such as lasting powers of attorney that enable others to look after your affairs when you are unable to, is disproportionate to the amount of time it actually takes to put these instruments in place, due to the fact that the effects, as we saw with Kate Garraway's situation, can be fairly catastrophic at a time when you also have the trauma of dealing with the situation itself, and perhaps significant changes in the abilities of a loved one. There's also the fact that the alternative to having lasting powers of attorney, which is a deputyship, can be quite onerous in terms of the amount of time applications to the court take, and indeed the cost of those applications. Just by way of contrast, the fees for a lasting power of attorney, or rather to register a lasting power of attorney, are £82 per LPA. The court fee for applying to have a deputyship order made is £365 at present. That is without taking into account the legal costs of either registering an LPA or making an application to the court for a deputyship order. But I would estimate that the cost of a deputyship order overall probably approaches double that of registering an LPA. In addition, having to apply for deputyship removes the choice of who looks after your affairs. So it may well be that the people you would have chosen as attorneys are the people who apply for deputyship, but there's no guarantee that the court will approve their appointment, and indeed the court may appoint professional deputies. who will be able to charge costs for that service, adding an additional burden to your estate. Lastly, and linked to the previous point, it can lead to dispute, generally where, for example, one family member objects to the appointment of another family member. By contrast, a lasting power of attorney, or creating a lasting power of attorney, really forces the donor to think about lots of these issues in advance and hopefully avoid such disputes within the family. So in conclusion, the pandemic has highlighted the real possibility of sudden losses of capacity due to, sudden losses of capacity due to debilitating illness. And where that does happen, the disproportionate effects on both the individual concerned and those close to them in relation to not having put a lasting power of attorney in place. And especially compared with the onerous nature of having to apply for deputyship. So that ends my talk on lasting powers of attorney, and I'll hand back to my colleague Tara McInnes.
Thank you, Stephen. Some real thought-provoking issues there. So unfortunately, there isn't any time for questions today, but if anyone does have any queries, then please feel free to contact us. Stephen's contact details are set out on the slide. And as I said at the very beginning of this presentation, this is the second video in our series of Emerging from Lockdown. So please do watch our other two videos. There's one on wills and estates, and the third is on disputes against estates and the impact of the pandemic on both of those. So it only remains for me to say thank you for joining us today. Goodbye and enjoy the rest of your day.